guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, I have had a tough week since the whole spring forward daylight savings time crap. I'm not a fan of us changing, an hour here, hour there. I don't know about you guys, but it doesn't work for me at all. And I know some folks say, well, it's just an hour, but that hour can really, screw you up. So this week has been just a bit of a tough one, and I think that we should pick a time and just like stay there. And here in Florida, we actually voted to do just that, but apparently it's not happening so far. So yeah, I don't know if we're ever gonna have that happen. But alas, I am here and I'm hoping to get a couple of videos done. I'm taking tomorrow off, tomorrow Friday from work. So I'm hoping to get a couple, 2 or 3 videos out this weekend. As you guys saw on my community post, Tommy Zeigler was denied a new trial. And to say I was disappointed, yeah, I was very disappointed. I really thought that the judge would grant something besides just denied. Let me pull up the Orange County clerk's site because everything is on there. We're not going to go through the entire thing because it's a lot. There's a lot of stuff on here. I mean, we definitely could in the future if you guys want me to, but so if you take a look right here, 3-6 denied, and there is a lot of other exhibits and such on here as well, and the motion is 44 pages in of itself, so I'm going to go through it as much as we can. I don't know if I'll end up reading the whole thing. I skimmed it, but I mean, we already know it was denied, so there's really not much else beyond the fact that Tommy's team is appealing to the Supreme Court of Florida at this point. So, but yeah, there's all kinds of other stuff here. You guys can see. There's 132 pages here, 106, 106, 89. So a lot of documents that were actually filed the end of last week, but that did not hit the clerk's website until this past Monday. So yeah, a lot to go through if you're into all that, which I usually am, but and I'll probably end up sifting through it at some point, but okay, so again, here is the actual order denying defendant's post-conviction motion. And of course, State of Florida versus William Thomas Zeigler Jr. This matter came before the court on defendant William Thomas Zeigler Jr.'s motion to set aside convictions based on newly discovered evidence filed on March 21st, 2025. The state of Florida filed its answer to defendant's motion for post-conviction relief on July 14, 2025. The court held a Huff hearing on August 7th, 2025. At the Huff hearing, Dennis H. Tracy III, Esquire, David R. Michelini, Esquire, Ralph V. Hadley III, Esquire, and John H. Pope, Esquire, appeared on behalf of defendant. Defendant Zeigler chose to waive his presence. Jacqueline N. Brown, Esquire, Ralph V. Seagobbin, Jr., Esquire, and Patrick A. Bobick, Esquire, appeared on behalf of the state of Florida. Joshua Snow, Esquire, appeared on behalf of the Attorney General's office. The court held an evidentiary hearing from December 1st, 2025 to December 5th, 2025. At the evidentiary hearing, attorneys Tracy, Michelini, Hadley, and Pope again appeared on behalf of defendant Zeigler. Mr. Zeigler was present. Attorneys Seagobbin, Brown, and Bobach appeared on behalf of the state of Florida. Attorney Snow appeared on behalf of the Attorney General's office. The court, having considered the motion, answer, and record, having considered the testimony and evidence presented, the argument of counsel, and being otherwise duly advised in the premises, finds as follows. Procedural history. On March 26, 1976, the state of Florida charged defendant by indictment with the first-degree murders of Eunice Zeigler, Virginia Edwards, and Perry Edwards in violation of Florida Statute Section 782.04. See indictment and then attachments, composite attachment. The same day, but by separate indictment, the state also charged defendant with the first-degree murder of Charles Mays in violation of Florida Statute Section 782.04. See in the indictment attached as composite attachment 1. So these are all referencing, obviously, all those attachments that we saw. On July 2, 1976, following a jury trial, a jury found defendant guilty of the first-degree murders of Eunice Zeigler and Charles Mays. See verdicts attached as composite attachment 1. The jury found defendant guilty of the second-degree murders of Virginia Edwards and Perry Edwards. See verdicts attached as composite attachment 1. On July 16, 1976, the jury rendered an advisory sentence to the court, recommending that defendant be sentenced to life imprisonment. See 7/16/76, advisory sentence attached as composite attachment 1. The trial judge sentenced defendant to death for the first-degree murders of Eunice and Charles. See judgments and sentences attached as composite attachment 1. The court sentenced defendant to consecutive terms of life imprisonment for the second-degree murders of Perry and Virginia Edwards. See judgments and sentences attached as composite attachment 1. Defendant appealed, and the Florida Supreme Court affirmed the judgments and sentences. Zeigler v. State, 402 Southern 2D, 365, Florida, 1981. Cert denied, 455 U.S. 1035, 1982. Defendant has filed several post-conviction challenges to his judgments and sentences. The Florida Supreme Court denied defendant's first petition for right of habeas corpus, Zeigler v. Wainwright, 421 Southern 2D1, Florida, 1982. It affirmed the summary denial of all but one of the 19 grounds raised in defendant's first post-conviction motion, Zeigler v. State, 452 Southern 2D, 537, Florida, 1984. It reversed the denial and remanded for an evidentiary hearing only on defendant's second ground, that his right to due process was violated when an actually or potentially biased trial judge presided over his trial. The trial court then denied the motion on this ground after an evidentiary hearing, and the Florida Supreme Court affirmed the denial. Zeigler v. State, 473 Southern 2D, 203, Florida, 1985. Go back up here and let's take a look at these 19 grounds, the little footnote here. Okay, the 19 grounds were: 1. That the trial court violated defendant's rights to due process and equal protection when it refused to admit evidence showing the results of a sodium berthol examination conducted on him. 2. That defendant's right to due process was violated when an actually or potentially biased trial judge presided over his trial. 3. That the grand jury indictment of defendant was invalid. 4. That the investigating agency and the state attorney exhibited a pattern of obstruction and delay and actual destruction and suppression of evidence. 5. That defendant's conviction and sentence were obtained by the presentation of evidence seized in violation of his Fourth Amendment rights. 6. That the prosecutor improperly commented to the jury on evidence. 7. That the jury deliberations were tainted by undue pressure from the trial judge and by the use of intoxicants. 8. That the trial judge improperly imposed the death penalty after the jury had recommended life. 9. That defendant was denied effective assistance of counsel at the guilt and penalty phases of his trial. 10. That the death penalty is imposed in Florida in an arbitrary, capricious, and irrational manner. 11. That the trial court failed to define the burden of proof to the jury. 12. That the trial court's construction of the aggravating circumstance of heinous, atrocious, and cruel was unconstitutionally broad and vague. 13, that the trial court failed to adequately guide and channel the jury's discretion. 14, that the trial court improperly found and weighed certain aggravating circumstances. 15, that the trial judge improperly limited consideration of mitigating circumstances to those enumerated in the statute. 16, that the instructions to the jury in the penalty phase improperly shifted the burden of proof. 17, that the Florida death penalty statute is unconstitutional as applied. 18, that because of an ambiguity in the scope of mitigating circumstances, persons sentenced prior to July 3, 1978 were deprived of a fully individualized sentence determination. 19, that defendant was deprived of due process when the state failed to provide notice of the aggravating circumstances upon which it would rely. And that actually makes complete sense. I agree with all of that. So those 19 all do apply to Thomas Zeigler. Defendant filed a second motion for post-conviction relief. He raised 5 grounds for relief. State v. Zeigler, 494 Southern 2D, 957, 958, Florida, 1986. The trial court summarily denied grounds 2 through 5, but granted an evidentiary hearing on the first. The trial court stayed the scheduled execution pending the hearing. The Florida Supreme Court reversed the trial court's order, granting an evidentiary hearing, denied all relief, and vacated the stay. You know, I have to say this. I know there is a handful of folks out there who still think that Tommy is guilty. I think that there's just so many things that were against Tommy, okay? And he didn't, and I don't believe he got a fair trial for many reasons, the judge being the biggest, okay? And obviously the jury said life, and the judge is like, well, hell with them. I'm going to give him, the death penalty. We're not even talking about the fact that law enforcement immediately, they were automatically on Tommy for the entire thing. There were all kinds of witnesses that lied, and now with the evidentiary hearing this past December, there is enough reasonable doubt, okay, that Tommy is innocent. And so this is why it blew my mind. I mean, if you want to throw out all these other, reasons, which is ridiculous, but the fact that DNA doesn't lie, okay? DNA doesn't lie. So it to me is like it's as if Tommy has been screwed from the get-go, and it's really crappy, because no, he's not the only one out there who this happens to, but I think he's one of the longest standing, definitely, he's the longest standing in Florida, but he's one of the longest standing fighting to get not only to get off of death row, okay, but to get exonerated. And it's just sad to me that, obviously they're going to appeal, but the sad fact is, he's probably gonna pass away in, behind bars, and, that really sucks. It really, really sucks, and that's just putting it mildly. Defendant next filed another petition for right of habeas corpus. He claimed entitlement to relief under Hitchcock v. Duggar, 481 United States 393, 1987, in which the United States Supreme Court found reversible error where the jury was instructed to consider only statutory enumerated mitigating circumstances, and where the trial judge declined to consider non-statutory mitigating circumstances. Zeigler v. Duggar, 524 Southern 2D, 419, 420, Florida, 1988. The Florida Supreme Court vacated defendant's sentences of death because it could not determine if the sentencing judge considered non-statutory mitigating evidence in his decision. As a result, the Florida Supreme Court ordered that a new sentencing proceeding be conducted. See, and this has not happened either. At the least, while he's trying to appeal, his guilt, the fact that he's on death row, it's just, it's disgusting. It truly is. Here's the 5 grounds. 1, the sentencing decision violated the 8th Amendment as constructed in Lockhart v. Ohio, 1978, Eddings v. Oklahoma, 1982, and subsequent rulings. 2, as a result of serious prejudicial jury misconduct involving racial bias and coercion, defendant was denied the right to a fair trial by an impartial jury as granted by the 6th and 14th Amendments. 3. The death sentences imposed upon defendant were based on unconstitutional aggravating circumstances which fundamentally distorted the sentencing process in violation of the 8th and 14th Amendments. 4. The state suppressed exculpatory evidence in violation of the 8th and 14th Amendments. And 5. The trial court imposed a sentence of death, notwithstanding the jury's recommendation on the basis of a presumption that death was appropriate if one aggravating circumstance was approved in violation of Tedder v. State, Florida 1975, Article 1, Section 16 and 22 of the Florida Constitution, and the 8th and 14th Amendments to the United States Constitution. Yeah. I mean, I understand, okay, for anyone who's saying, well, the judge can override, what the jury recommends. Well, yeah, absolutely they can. But in this circumstance, there was so much, the judge already didn't like Tommy, okay? The judge already had a bias against Tommy from the get-go. And then the one juror that was holding out, he contacted her doctor to give her medication. And then she went back in and she changed her verdict. I mean, I'm telling you, corruption out the ass. It's disgusting. Judge Formet presided over the resentencing. On August 17, 1989, defendant was again sentenced to death for the first-degree murders of Eunice Zeigler and Charles Mays. Judge Formet found the following aggravated circumstances. 1. Defendant had been previously convicted of another capital felony or felony involving the use of violence. 2. Defendant's murder of Charles Mays was for the purpose of avoiding lawful arrest. 3. Both murders were committed for purgatory gain. And 4. The murder of Charles Mays was especially heinous, atrocious, or cruel. Well, I think the fact that Charles Mays attacked Eunice and the Edwards and went after Tommy, which is exactly what I think happened, I think that's pretty damn heinous and atrocious. So, I hate to say it, but now that we're already at this point where this has been denied for like what it feels like the 10th zillion time for Tommy, it's like the state of Florida is just like, yeah, you're not going anywhere. And, yeah. Let's see. He found one statutory mitigating circumstance. Defendant has no significant history of prior criminal activity. Well, of course he doesn't. He didn't do anything before that. As to non-statutory mitigating circumstances, Judge Formet found that defendant's character was no more good or compassionate than society expects of the average individual, and that the testimony presented did not establish unusual participation in church and community activities. He further found that defendant had a good prison record, adapted well to prison life, and is an asset as an inmate. Yeah, Tommy's had a very good record as an inmate, which not all these guys can say that. And finally, that testimony revealed no propensity for spontaneous violent conduct. However, there was no evidence that defendant would not engage in the cold and calculated violent conduct evidenced by the murders for which he stands convicted. Yeah. Defendant appealed and the Florida Supreme Court affirmed. I mean, my only answer to all this appeals and constant denials is that Tommy is just screwed. I mean, I don't know how else to say it, guys. It's like, it doesn't matter that this was 1975, Christmas Eve of 1975. It's at this point, it's like Tommy is screwed, okay? I mean, there's really, to me, it's like, the evidence was clearly there. The DNA evidence was there. And I was in court for one day. And I listened to all this stuff. I to me, it's like the evidence is there. It's like the state of Florida is like, yeah, we don't give a crap. Yeah. Defendant then filed his third motion for post-conviction relief. He raised 5 claims. Zeigler v. State, Florida, 1993. Certified, denied. 1994. The trial court summarily denied claims 1, 2, 4, and 5, and denied claim 3 after an evidentiary hearing. The Florida Supreme Court affirmed. Defendant's petition for right of habeas corpus was denied. Zeigler versus Singularity, that's Florida 1994. Yeah. Defendant's fourth post-conviction motion followed shortly after. That motion raised 11 grounds for relief. Zeigler versus State, Florida 1995. At the hearing on that motion, defendant also made his first motion for release of evidence for DNA testing. The trial court denied both motions, and the Florida Supreme Court affirmed. As to the motion for DNA testing, the court held that the claim be procedurally barred, and that even if it was not, his request for DNA typing is based on mere speculation, and he has failed to present a reasonable hypothesis for how the new evidence would have probably resulted in a finding of innocence. I'm telling you guys, they're going to appeal, okay? Hadley and the team are going to appeal to the Supreme Court, and they're going to deny it again. They're going to affirm this finding. If you want to think that our justice system is fair, I think it's not always fair. I think it's really crappy in certain cases, and this is one. So here are the 5. They were: 1, the state failed to disclose the identity of known guilt phase witnesses whose testimony did not fit the state's theory of the case. 2, the state withheld prior inconsistent statements by 3 witnesses who testified during the guilt phase of the trial. We know who some of them are by now. 3, the state fabricated evidence that was presented at trial, specifically a bullet discovered in an orange grove. Yeah. 4, various allegations that demonstrated a pattern of misconduct by the state. And 5, the jury's verdict of guilt was tainted by judicial intervention into its deliberations, tantamount to coercion. The more you read about the defense's reasonings why this all should be reconsidered, you see how he's just screwed, right? The 11 grounds were: 1, the defendant was improperly precluded at the resentencing hearing from introducing evidence that was relevant to the mitigating and aggravating factors. 2, the Florida Supreme Court failed to consider residual doubt. 3, the resentencing court's override of the jury recommendation of life was unconstitutional. 4, the Florida Supreme Court failed to conduct a meaningful appellate review of the jury override. 5, the Florida Supreme Court failed to conduct a proportionally review. 6, the previous conviction of a violent felony aggravator is vague and was inconsistently applied. 7, there was insufficient evidence to support the avoiding lawful arrest aggravator. 8, the propensatory gain aggravator unconstitutionally doubles the factor of avoiding arrest. Yeah, because remember they said that he did it because he took a life insurance policy out on his wife. Yeah. 9, the heinous, atrocious, and cruel aggravator was not limited and applied inconsistently and arbitrarily. 10, actual innocence. And 11, Florida's system of capital punishment is unconstitutional. In 2001, defendant again requested that evidence be released for DNA testing to support his clemency proceedings. Zeigler versus State, Florida 2007. The trial court granted the motion and released the evidence for DNA testing. In 2003, after the testing was complete, defendant filed his motion to authorize pneumatic pro-tunc DNA testing in his 5th post-conviction motion. That says, looks like, see also defendant's 2003 motion to vacate convictions based upon newly available evidence attached as composite attachment 3. He argued that the DNA testing corroborated his theory that Charles Mays and 2 others committed the murders, and that the results rebutted the state's theory that he struggled with Perry Edwards. The trial court denied the motion, and the Florida Supreme Court affirmed. Defendant's subsequent requests for additional DNA testing were denied. Zeigler versus State, 2013. And then Zeigler versus State, April 21st, 2017. And denied in 2017. In 2013, defendant filed his sixth post-conviction motion. He raised 4 claims: Zeigler v. State, Florida 2013, certified denied 2014. The trial court summarily denied each claim, and the Florida Supreme Court affirmed. And these reasons were: 1, that the state violated Brady v. Maryland, 1963, by withholding information concerning a material witness, Robert Foster, and information regarding an attempted armed robbery near defendant's furniture store on the night of the murders. 2, that the state violated Gigolo v. United States, 1972, by presenting and allowing the false or misleading testimony of Detective Fry and Chief Thompson to go uncorrected. Yeah, gotta love Detective Fry, huh? 3, that defendant is entitled to a new trial based on the allegedly newly discovered evidence concerning Robert Foster and the attempted armed robbery near his furniture store on the night of the murders. And 4, that defendant's conviction should be vacated because he has established that he's actually innocent. On May 20th, 2021, the state of Florida and defendant filed their joint motion and stipulation regarding the release of evidence for DNA testing. Through this joint motion, the parties agreed to further DNA testing. Ultimately, the court granted the joint motion and entered its order regarding the release of evidence for DNA testing on December 19th, 2022. On May 19th, 2023, the court entered its supplemental order regarding the release of evidence for DNA testing, in which additional items of evidence were released. Following the conclusion of said DNA testing, and on March 21st, 2025, defendant filed the instant motion. Through this motion, defendant raises 2 claims. In Claim 1, he asserts he's entitled to a new trial because the newly discovered DNA evidence would probably produce an acquittal on retrial. In Claim 2, he argues his conviction should be vacated because he's actually innocent. Yeah. Facts of the case. Defendant was convicted of the first-degree murders of Eunice Zeigler and Charles Mays, and the second-degree murders of Perry Edwards and Virginia Edwards. The murders occurred on December 24th, 1975. First, the court details the facts as shown by the evidence at trial. In this section, the court will describe the events the state argued they occurred and the evidence supporting them. Then the court will describe the events of that night as defendant argued and as evidence in support. Second, the court will detail the newly discovered evidence and all other evidence that would be admissible in a new trial. All right. 1. Facts and evidence at trial. A. The state's rendition of events. So this is obviously, we've heard all this before, but obviously they're going back through it for this denial. A. The state's rendition of events. The state asserts that defendant planned to murder his wife to collect life insurance proceeds and then blame the crime on others. Yeah, well, that was an easy enough reason, okay, that the investigators, Detective Fry and company, pulled out of their ass, and it's like, oh, well, Tommy took this life insurance policy out on his wife, so surely he's planning on killing her. Yeah. Eyewitness testimony and corroborating evidence. In April or May of 1975, defendant questioned Mary Stewart about acquiring illegal guns. He asked her about a man named Smitty who might be able to obtain these guns. Around June of 1975, defendant also asked Edward Williams, a longtime acquaintance and handyman for the defendant, to acquire hot guns for him. In the past, defendant had asked Mr. Williams to obtain a gun for him to give to Ms. Beaufort. Mr. Williams contacted a man named Frank Smith, called Smitty, to see about obtaining those hot guns. From Mr. Smith's home, Mr. Williams called defendant by telephone. Mr. Smith was present with Mr. Williams during the call. Mr. Williams recognized the voice on the other end of the line as defendant's. Defendant requested to speak to Mr. Smith and did so. Defendant identified himself over the phone while speaking with Mr. Smith. Defendant again requested that any guns he obtained be untraceable. Defendant provided Mr. Smith with a telephone number to call. Rather than buying hot untraceable guns, Mr. Smith purchased 2 .38 caliber RG model 31 revolvers from a pawn shop. Those sales were recorded on June 20th, 1975. After purchasing those guns, Mr. Smith used a payphone to call the previously provided telephone number. He recognized the voice on the other end as the same voice from the prior call. Defendant identified himself on this call as well. The next day, defendant gave Mr. Williams a sealed envelope containing money to take to Mr. Smith. Mr. Williams exchanged the envelope for a bag containing the guns. He then brought the bag to the defendant's house and gave it to Eunice Zeigler to give to the defendant. Mr. Smith never disclosed that the guns were in fact not hot or untraceable. So this Mr. Williams, exchanged these guns with Eunice, and allegedly these are the guns that Tommy used to kill her and her parents. Right. Okay. All right, guys. Later still, defendant obtained two separate $250,000 life insurance policies on Eunice's life, one issued by Gulf Life Insurance Policy and the other by Life and Casualty Company of Tennessee. Ultimately, Eunice's life was insured for at least $500,000. The remainder of the evidence relevant for purposes of this motion centered around the events of December 24, 1975. Curtis Dunaway was an employee of Zeigler Furniture Store and arrived to work a bit after 7 a.m. He left work that day around 6:20 p.m. When closing the store that evening, Mr. Dunaway removed the cash from the register and secured it in a safe. Typically, the floodlights across the front of the store were left on and perhaps some hanging lamps as well, even when the store was closed. When Mr. Dunaway attempted to turn on the typical lights, defendant instructed him not to do so. Unusually, only the lights left on in the store that night were a Christmas wreath and a tree lamp with two lights. The store also had additional automatic lighting across the front, which usually turns on at 6 p.m. They did not turn on that light. The controls for the automatic lights were in defendant's office. Mr. Dunaway does not recall any other time the store was closed with every light off in this manner. Once the store was closed around 6:20 p.m., Mr. Dunaway left and drove to defendant's house. At the house, and because Mr. Dunaway's car was acting up, defendant and Mr. Dunaway swapped cars. Mr. Dunaway left his 1972 Oldsmobile with defendant. Mr. Dunaway owned no pistols, and there were no pistols in his car when he left it with defendant. However, on the morning of December 25, 1975, a Smith & Wesson .38 caliber revolver was recovered from the backseat of the car, which was parked at defendant's residence. Defendant had purchased that gun earlier in the year from a gun store owned by Raymond Ushery. Mr. Dunaway usually kept a blue towel in the backseat of his car, and it was there when he left the car with defendant. After the murders, the blue towel was recovered from a cabinet in the back of the store. Group A human blood was also found on the blue towel. At approximately 7:05 p.m., Thomas Hale observed defendant and Eunice driving together with Eunice in the passenger seat. Mr. Hale has known defendant most of his life and knew Eunice. Defendant and Eunice were headed in the direction of the Zeigler Furniture Store. Defendant also testified that he was driving around this time. However, defendant testified he was alone. Around 7:25 p.m., Barbara Tinsley heard what she thought were firecrackers or explosion sounds originating from the direction of the Zeigler Furniture Store. The clock recovered from the Zeigler Furniture Store corroborates this time. Mrs. Zeigler was visiting her parents, and the Zeigler Furniture Store is almost directly behind her parents' house. Approximately 15 minutes later, around 7:40 p.m., Mrs. Tinsley heard a second set of explosions. Also around 7:40 p.m., Barbara Woodard was leaving the shopping center across the street from W.T. Zeigler Furniture Store. Ms. Woodward testified that no lights were on in the furniture store, but she observed a white male standing inside by the door. At 7:30 p.m., defendant had arranged to meet two individuals. Defendant was to meet Charles Mays at the Zeigler Furniture Store and Edward Williams at defendant's home. Based on this arrangement, Mr. Mays left his home between 6:30 and 7 p.m., approximately 6:45 p.m. On his way to meet defendant, Mr. Mays picked up an acquaintance, Felton Thomas. Mr. Mays and Mr. Thomas arrived at the Zeigler Furniture Store after dark, but Mr. Thomas could not state a specific time. About 5 minutes after they arrived, a white man approached them, whom Mr. Thomas identified in court as defendant. Defendant asked Mr. Mays and Mr. Thomas to come with him, and all three men got in defendant's car. Defendant wanted Mr. Mays to test the accuracy of some guns, and he drove them to an orange grove to do so. Yeah, this was later on changed by one of these witnesses. Those guns were in a grocery bag in the car. Mr. Mays fired one of the guns out of the car window a few times, and at the defendant's request, Mr. Thomas also fired a single shot from one of the guns. A bullet was later recovered from the same orange grove. That bullet matches the class characteristics of one of the guns recovered, in this case, the Security Industries 38 Special. Notably, expert testimony shows that the rifling impressions made by that particular Security Industries gun were uncommon and matched the bullet recovered from the grove. Because that couldn't have been planted or anything, right? Defendant drove them all the way back to the furniture store. Upon returning to the store, defendant pulled up next to a box with a switch and instructed Mr. Thomas to pull it down. Mr. Thomas hesitated but ultimately did. Defendant informed Mr. Mays and Mr. Thomas that the store was still locked and that if Mr. Mays wanted his TV, they'd have to jump the fence and crank a window. Defendant and Mr. Mays jumped the fence, but when defendant picked up a pipe or rod and rammed it into the building, Mays objected and jumped back across the fence. Defendant then decided to get a spare key at his home, and all three men returned to defendant's car. Defendant drove them to a home with a pickup truck and another vehicle out front. Defendant messed around in the garage before coming back out. He walked past the occupied car toward the pickup truck and then returned to the car with a box. Defendant gave the box to Mr. Mays and told him to reload the gun. Mr. Thomas also described a bag into which defendant placed guns. The bag was recovered in a cabinet in the store. The bag contained cartridge cases consistent with those fired from one of the guns, the palm print of the defendant, and human blood. Once again, all three returned to the store. Defendant unlocked the store door and said that all three should bring the TV up front. Mr. Mays went to bring his van closer, but defendant insisted that the TV be brought up front first. Mr. Mays entered the store. Defendant asked Mr. Thomas to come inside as well, but Mr. Thomas declined and asked that some of the lights be turned on first. Because Mr. Thomas got a bad feeling, he decided to leave. He did not see Mr. Mays alive again. Edward Williams also met with the defendant that night. The morning of December 24th, defendant reminded Mr. Williams to stop by defendant's house at 7:30 p.m. The indicated intent was for Mr. Williams to assist defendant in moving Christmas presents for his father and father-in-law. Mr. Williams drove his blue pickup truck to defendant's home that night. He arrived at 7:28 p.m. and defendant's truck was parked outside the garage. Mr. Williams went to knock on the door but found a note instead. The note said, "Edward, I'll be back in 10 minutes. TZ." Mr. Williams waited about 10 minutes, and at approximately 7:38 p.m., defendant returned to the home. Defendant arrived with two other people in his car. Defendant went inside, stayed a few minutes, and came back out. He stopped by Mr. Williams' pickup truck and informed Mr. Williams that he'd be back in 10 minutes. Around another 25 to 30 minutes elapsed as Mr. Williams waited for defendant to return. By then, it would have been between 8 and 8:10 p.m. When defendant returned, no one was with him. He was driving pretty fast when he pulled into the garage. He hit his brakes hard enough for the car to bounce as it suddenly stopped. Defendant got out of his car with the little bag and ran over to a sink or wash tub in the garage. At the sink, defendant wet a towel or rag and then used it to wipe down his car. He went back to the sink, put the towel back, and headed towards Mr. Williams' pickup truck. At which point, Mr. Williams noticed dark staining on defendant's pants. Defendant got into Mr. Williams' truck with the little bag, and Mr. Williams drove them to the furniture store. Arriving at the store, Mr. Williams let defendant out at the front of the store so the defendant could go through the store and open the back gate. Defendant took the little bag with him. Mr. Williams pulled around back and parked. Defendant had gone into the store and instructed Mr. Williams to come inside. Mr. Williams went inside after defendant. Defendant then pointed a gun at Mr. Williams' chest. He pulled the trigger 3 times, but the gun did not fire. Mr. Williams ran back outside, but found the back gate locked. Defendant also testified he locked the back gate. Defendant followed Mr. Williams outside, claiming he didn't know it was Mr. Williams, and repeatedly asked Mr. Williams to go back inside the store. Defendant continued his efforts to get Mr. Williams back in the store, including handing Mr. Williams the gun, kneeling and stating, "Edward, if you don't go in there, you're going to frame me." At that point, Mr. Williams saw blood on defendant's face. He managed to convince defendant that he'd go inside if defendant opened the gate and moved his truck. Defendant got into Mr. Williams' truck, allowing Mr. Williams to jump over the fence and flee. Mr. Williams kept the gun that defendant had handed him earlier. Defendant did not follow him. Mr. Williams ran to a nearby Kentucky Fried Chicken, went inside, and asked to use the phone. An employee of that Kentucky Fried Chicken confirmed that a black man entered the store that night, appeared scared, and asked to use the telephone. That employee provided Mr. Williams with the Winter Garden Police Department phone number, but when Mr. Williams called, he apparently had the wrong number. That's convenient. Mr. Williams left the Kentucky Fried Chicken after he did not reach the police. He encountered two women and asked them for a ride to Orlando, but ultimately asked them to drop him off at a Texaco station to pick up his other vehicle, a gray Camaro. Yeah. The woman dropped Mr. Williams off at that Texaco. He reclaimed his vehicle and continued to Orlando, intending to go to the sheriff's office. The operator of that Texaco corroborates that Mr. Williams reclaimed his Camaro that night. On his way to the sheriff's office, Mr. Williams became nervous and feared an accident. He stopped at his friend Mary Stewart's house. Mr. Williams told Miss Stewart and the others present at the house that Tommy tried to kill me in the store. Mary Stewart and her son-in-law drove Mr. Williams in his Camaro to the sheriff's office. Mrs. Stewart corroborates Mr. Williams' testimony, and she testified that he arrived at her home between 9:30 p.m. and 10 p.m. Once at the sheriff's office, Mr. Williams attempted to relay his report, but was instructed to return to Winter Garden. The deputy stationed at the sheriff's office information desk that night also corroborates Mr. Williams' story. That deputy testified that he encountered Mr. Williams at 10:47 p.m. Mr. Williams was then driven, still in his Camaro, back to Winter Garden. The gun that he received from the defendant was left on the floorboard of his Camaro. Officers recovered the weapon and identified it as a Security Industries 38 Special. Defendant purchased that gun earlier in the year from Mr. Usury. Okay, recovered weapons. 8 guns were found to have been fired in the furniture store that night. Yeah, and they're thinking that all these guns were fired by Tommy. That's something else. 1 Security Industries 38 Special Revolver, 2 Smith & Wesson 38 caliber revolver, 3 Colt Lawman Mark III 357 Magnum caliber revolver, Burgo 38 Special Caliber Derringer pistol, Smith & Wesson Model 61-3 22 caliber semi-automatic pistol, Beretta 22 short caliber pistol, RG Model 31 38 caliber revolver, and another RG Model 31 38 caliber revolver. There are no indications that other guns were used that night, but the state's expert conceded that he could not eliminate the possibility of another gun being involved. Defendant purchased the Security Industries 38 Special Revolver, the Smith & Wesson 38 caliber revolver, and the Colt Lawman Mark III 357 Magnum caliber revolver from Raymond Usury. He admitted to owning the Burgo 38 Special Caliber Derringer pistol. The Smith & Wesson Model 61-3 22 caliber semi-automatic pistol had been loaned to defendant by Donald Fickery. Defendant purchased the Beretta 22 short caliber pistol from Fred Crawford. Defendant purchased through Edward Williams and Frank Smith both RG Model 31 38 caliber revolvers. Each of the weapons appeared to have been wiped clean, except that the Colt Lawman Mark III 357 Magnum caliber revolver had what appeared to be visible fingerprints. However, there were not enough for identification. And why would they be wiped clean if he was trying to frame them at the orange groves? Yeah, we've talked about that before. The other recovered weapon was what has been described as a crank. This crank is a roller for the rug rack at the store and was kept with rolls of linoleum. The crank was found lying on Mr. Mays' right arm just above the wrist. This crank had caused the blunt force injuries suffered by Perry Edwards and Charles Mays. Blood group A, human blood, was found on this crank. Eunice Zeigler, Charles Mays, and Perry Edwards were all blood group A. Victims, injuries, and cause of death. Of course, at some point that night, Eunice Zeigler, Virginia Edwards, Perry Edwards, and Charles Mays were killed. All 4 victims were killed sometime between 7 p.m. and 9 p.m. Eunice Zeigler was found lying face up in a small kitchen near the back offices. She died of a single gunshot wound to the left occipitable area of her head. Her left hand was in her coat pocket, which is still very odd to me. Definitely set up. While no positive identification of the firing weapon could be made, the bullet recovered from Eunice Zeigler could have been fired by either of the .38 caliber RG Model 31 revolvers. Virginia Edwards was found approximately 10 to 15 meters from the store's main entry exit. Virginia had 2 gunshot wounds, 1 bullet through her arm, into the chest and lungs, through the liver and stomach, and came to rest on the left side of her abdomen. The second bullet went through her finger and entered the cranial cavity. Gunpowder tattooing was present on her finger. The second bullet was the cause of her death. Both bullets were recovered by Mrs. Edwards' body. The bullet recovered from Mrs. Edwards' abdomen was fired by the .38 caliber RG Model 31 revolver. The bullet recovered from Miss Edwards' head was fired by the Security Industries .38 Special. Perry Edwards was found face down near the back of the store by a door leading to the back storeroom. He was turned face up at some point. He had 5 gunshot wounds. Mr. Edwards was shot in both his left and right shoulders. The bullets passed through both. He also received a gunshot wound to his right ear. It too went through and through. Finally, Mr. Edwards had 2 gunshot wounds to his head that ultimately caused his death. He showed evidence of gunpowder tattooing. Both bullets recovered from Mr. Edwards were fired by the Security Industries .38 Special. In addition to the gunshot wounds, his head also had at least 14 lacerations or contusions caused by a blunt instrument. Charles Mays was found approximately 5 meters from Perry Edwards, also near the back of the store. Mays was found lying face up with his trousers slipped down. He had suffered 2 gunshot wounds and multiple blunt force injuries. Mr. Mays was shot in the back, and the bullet went through and through. The other gunshot wound went in through Mr. Mays' lower chest and exited from the right lower back. No bullets were recovered from Mr. Mays' body. Unlike the other victims, Mr. Mays' cause of death was blunt force trauma. Mr. Mays' right hand showed swelling, abrasions on the dorsal surface, and knuckles caused by a blunt instrument. He suffered 8 head wounds caused by blunt force trauma. Some of those wounds caused fractures extending through the skull to the floor of the cranium. One of Mr. Mays' teeth was knocked from its socket. It was found inside his mouth. Defendant's injuries. Defendant also suffered injuries that night. Defendant had a single through-and-through gunshot wound to the right side of his abdomen. The bullet passed through without striking any internal organs. Defendant had a contused area on the right occipital region of his head, but there were no lacerations or abrasions there. He had a small abrasion on the front part of his right leg and a small area of intromesis, a black and blue area over his left kneecap. There was also a superficial, non-bleeding abrasion on his left cheek. While at the hospital, defendant complained of pain and soreness in both of his index fingers. On the distal volar surface of the right index finger, the treating physician noticed a contusion. Blood group evidence. Each of the victims and defendant had their blood group identified. Eunice Zeigler, Perry Edwards, and Charles Mays had group A blood. Virginia Edwards had group O blood. Defendant had group O blood. No subgroup typing was performed, although it was available at the time. Evidence from defendant's clothing. At trial, Professor Herbert McDonald testified about bloodstain patterns. Professor McDonald testified that the front of defendant's outer shirt had splatters of blood called medium velocity impact spiders. The right sleeve of the shirt also had stains consistent with medium velocity impact spiders. Such stains would be consistent with defendant having used an object to beat someone. The same shirt also had heavy stains on the back. These stains were not transfer stains from the floor. These stains would also be consistent with defendant using a heavy, irregular object to beat someone and blood flying off the object on an upswing and falling back onto the shirt. Defendant's white shirt also had a large, soaked-through blood stain in the armpit area. These stains were identified as coming from someone with Group A human blood. B. The defendant's rendition of events. The defendant asserts that he and his family were all victims of a robbery gone wrong. Mr. Zeigler's testimony regarding Christmas Eve. About a week before Christmas Eve, Tommy Zeigler asked Mr. Williams to meet him at home at 7 p.m. on Christmas Eve to help move some presents for Mr. and Mrs. Edwards. That morning, Charles and Mattie Mays came by the furniture store and bought 3 pieces of linoleum. Mr. Mays asked Mr. Zeigler if any secondhand television sets were available for purchase. As it happened, Mr. Zeigler was trying to sell a secondhand TV for someone else. Mr. Zeigler informed Mr. Mays that the TV set would cost $350, cash only. Around noon, Mr. Mays returned to the store to pick up his linoleum, but Mr. Zeigler never arranged for Mr. Mays to pick up the TV at 7:30 p.m. Later still, Mr. Zeigler stopped by Mr. Mays' home to drop off a box spring. Mr. Zeigler again did not ask Mr. Mays to come to the store at 7:30 p.m. that night. He did not believe Mr. Mays could pay for the TV. The store closed that night sometime between 6:30 p.m. and 6:40 p.m. Before he left, Mr. Zeigler instructed his employee, Mr. Dunaway, not to turn on the overhead lights up front. He did not believe there would be many people window shopping on Christmas Eve. See, that to me is a reasonable explanation. The next day is Christmas. Most people at that time, they would be at home. He did leave a large Christmas wreath lit, some chain lamps, and a pole lamp. The store had some other lights set to turn on by timer. The timer should have been functional that night. With the store closed, Mr. Zeigler headed home in his truck. When he parked at home, he locked the door on the left-hand side. The right-hand side does not lock. Mr. Zeigler kept his Security Industries .38 Special revolver in the front compartment of his truck desk. The last time he saw the gun was up to 5 weeks before Christmas, and he did not know if that gun was still in his truck that day. At home, he met with Mr. Dunaway, and ultimately they exchanged cars. Mr. Dunaway came inside and spoke with Eunice Zeigler and Virginia Edwards while Mr. Zeigler checked on his cats. Mr. Dunaway eventually left at approximately 7 p.m. Sometime between Mr. Zeigler's arrival home and 7 p.m., Eunice, Virginia, and Perry left the home to go to the furniture store. Eunice and her parents were going to the store to pick out a Lazy Boy recliner for her father, after which they planned to attend a candlelight service at the First Baptist Church. While they attended church, Mr. Zeigler planned to pick up 3 gifts kept at the furniture store. Shortly after 7 p.m., Mr. Williams still had not arrived as planned. Mr. Zeigler wrote Mr. Williams a note stating, "Edward, I'll be back in 10 minutes, TZ," and stuck it in the door. Mr. Zeigler then left in Mr. Dunaway's car to go buy some liquor at the liquor store. While driving to the store and in an aggravated state, Mr. Zeigler decided to return home because he thought he would be late to the Van Demeter party. When he made it back home, Mr. Williams was parked behind Mr. Zeigler's truck. The windows on Mr. Dunaway's car were up. Mr. Zeigler went into the garage, left the keys to Mr. Dunaway's car therein, and got into Mr. Williams' truck. Mr. Zeigler was not carrying anything at this time, nor did he wipe down Mr. Dunaway's car. Mr. Williams drove them to the furniture store and pulled into the side drive. Mr. Zeigler noticed that the Edwards car was parked out front, but didn't think much of it. He was not paying attention to whether the store's lights were on. Mr. Williams pulled around to the side, and Mr. Zeigler got out and unlocked the gate. After Mr. Williams pulled through the gate, Mr. Zeigler locked it again as a routine precaution. As Mr. Williams parked his truck, Mr. Zeigler unlocked the hall door, went inside, and flipped the light switch on. The lights did not turn on. Mr. Zeigler attributed this to Mr. Dunaway having mistakenly thrown the wrong breaker. He proceeded into the main body of the store and attempted to turn on more lights, but those did not turn on either. Mr. Zeigler was then hit over the right side of his head and fell to the floor. He lost his glasses in the fall, and with them his ability to see. All he saw next were 2 blurs coming at him. He drew a Smith & Wesson Model 61.3 .22 caliber semi-automatic pistol from the holster and attempted to fire it. It jammed. He ejected the shell and tried to fire it again, and it jammed again. He does not know if the gun actually fired anything. Accordingly, he threw it. At this point, Mr. Zeigler started flying through the air, bouncing off the walls, refrigerators, and shelves in the back area. He heard glass breaking. He presumed one of the blurs was as tall, if not taller than him, but the other blur was shorter. Mr. Zeigler was scared to death, fighting and being bounced off the northern wall of the store. He was thrown into the hall, hit some chairs and a desk. From the desk, Mr. Zeigler was able to retrieve his Colt Lawman Mark III .357 Magnum caliber revolver. He was then bounced back out into the main showroom, at which point he believes he fired the .357 Magnum. He could not tell whether he fired it, but it could have been several times. He then started swinging the .357 Magnum with everything he had. He was swinging at the top and bottom of his assailants as hard as he could, and he's sure he connected with something. Mr. Zeigler was then thrown against the linoleum racks and hit the floor, and he lost the Magnum somewhere here. As he tried to get off the floor, he was shot. Whoever shot him was further than 6 inches away. After he was shot, he hit the floor again. Time became disjointed for him, and he was disoriented. He heard someone say, "Mays has been hit. Kill him." His assailants then left. Mr. Zeigler began crawling around looking for his glasses. As he did, he kept finding Christmas bows that had been knocked to the floor. He never found his glasses. But during his search, he crawled over a body in the back area. He could not identify who it was, but the body was in the back area near the linoleum racks. He could not identify who it was, but the body was in the back area near the linoleum racks. Eventually, Mr. Zeigler was not sure how long. He was able to obtain a pair of glasses from his desk. He was in significant pain at this point. After obtaining his glasses, Mr. Zeigler went to the service counter and picked up the telephone to call Ted Van Dieter's home. Mr. Van Dieter answered, and Mr. Zeigler asked to speak to Don Fickey, the chief of police for Winter Garden. That call was made around 9:15 p.m. He informed Chief Fickey that he had been hurt at the store. At some point, a stool Mr. Zeigler sat on or bumped into fell over, and he went to sit up in a lawn chair up front to await assistance. The chief of police for Oakland, Robert Thompson, was also present at Mr. Van Dieter's home that night. Chief Fickey and Chief Thompson proceeded to the furniture store. When Chief Thompson arrived, Mr. Zeigler called out to him. Mr. Zeigler was bloody, holding a ring of keys. Blood was spattered across Mr. Zeigler's face. He had a large gunshot wound, and Chief Thompson drove him to West Orange Memorial Emergency Room. At the hospital, Mr. Zeigler told Chief Thompson that Charles Mays is the one who shot him. He also informed Chief Thompson that he shot Charles Mays as well. Chief Thompson also remembers that Mr. Zeigler began babbling about Christmas presents. Mr. Zeigler underwent a laparotomy to assess any internal damage from the gunshot wound. No major organs were damaged, and Mr. Zeigler recovered well from both the gunshot wound and laparotomy. Mr. Zeigler states he did not shoot Eunice, Virginia, or Perry, nor did he beat Charles Mays. He denies attempting to shoot Edward Williams. Mr. Zeigler's evidence regarding Edward Williams. Boyd Holt runs a barber shop in Winter Garden. Mr. Holt saw Mr. Williams in the afternoon of December 24th. Mr. Williams came by for money, and Mr. Holt gave him $20. Around 7 p.m., Mary Wallace saw Mr. Williams wearing khaki-colored pants and a khaki-colored jacket and a flannel shirt with stripes and different colored checks. Mr. Williams' clothes in evidence do not match Miss Wallace's testimony about the khaki colors. It takes about 2 minutes and 45 seconds to drive from Mr. Williams' apartment to Mr. Zeigler's home. Wyman Jones Jr. saw 2 cars parked in front of the furniture store around 7:20 p.m. He later assumed one was Edward Williams' car. 2 witnesses testified that sometime after 9:15 p.m. they were at the Kentucky Fried Chicken across from the street from the furniture store. The Kentucky Fried Chicken was closed at this point. Around that time, a 50 to 55-year-old black man approached seeking to use the telephone to contact the sheriff's office. The newly discovered evidence. Here the court makes its findings as a fact to the newly discovered evidence based on the evidentiary hearing. 1. Multiple items of evidence were tested by the Forensic Analytical Crime Lab, FACL. 2. The testing conducted on the submitted evidence was comprehensive, sensitive, and capable of separating profiles from mixed DNA samples. 3. The analysts collected 232 samples from 43 items of evidence. 4. The testing was collaborative. Defendant's team in the state of Florida were involved in regular communications with FACL, and both could request testing on any of the submitted items. 5. Ms. Kristen Hardy-Connell is the FACL analyst who performed the DNA testing in this case. She testified at the evidentiary hearing, and the court finds her to be credible. 6. Mr. Kenton Wong is a FACL forensic scientist who performed bloodstain analysis on the items of evidence to suggest, in collaboration with Ms. Hardy-Connell, which samples should be subject to DNA testing. 6. Mr. Kenton Wong is a FACL forensic scientists who performed bloodstain analysis on the items of evidence to suggest, in collaboration with Ms. Hardy-Connell, which samples should be subject to DNA testing. He testified at the evidentiary hearing, and the court finds him to be credible. 7. Mr. Richard Eichenblum is a self-employed forensic scientist who reviewed the DNA reports of FACL and performed his own bloodstain pattern analysis. He testified at the evidentiary hearing, and the court finds him to be credible. 8. Ms. Anna Cox owns a private forensic consulting business, and she conducts her own bloodstain pattern analysis. She testified at the evidentiary hearing, and the court finds her to be highly credible. 9. The samples chosen for DNA testing were representative of the associated bloodstaining. 10. The attack on Perry Edwards would have produced blood spatter. 11. Perry Edwards' attacker would have been expected to have accompanying blood spatter on their clothing. Both the defense and state experts agree on this point. 12. The results for the samples taken from defendant's outer shirt show the presence of the DNA of 2 individuals, defendant and Charles Mays. From all but one of the samples, Perry Edwards, Virginia Edwards, and Eunice Zeigler are excluded as contributors. 13. The results for the samples taken from defendant's pants show the presence of DNA of 2 individuals, defendant and Charles Mays. From all but one of the samples, Perry Edwards, Virginia Edwards, and Eunice Zeigler are excluded as contributors. 14. The results from the samples taken from defendant's socks indicate the presence of DNA from 2 individuals, defendant and Charles Mays. Perry Edwards, Virginia Edwards, and Eunice Zeigler were excluded as contributors in all but one result. 15. The results for the samples taken from defendant's shoes show the presence of DNA of 3 individuals, defendant Charles Mays and Perry Edwards. A. Perry Edwards was a contributor of DNA in 2 of the 3 samples processed from defendant's shoes. His DNA was detected in samples 34-1D and 34-2A. B. Sample 34-1D only demonstrated limited support that Perry Edwards was a contributor, but sample 34-2A showed strong support for that proposition. C. Defendant's expert, Mr. Eichenblum, does not characterize the staining from sample 32-2A as blood spatter. He made that determination based on the irregularity of the stain size and shape. D. The state's expert, Mrs. Cox, examined not just the photographs but the shoes themselves. Ms. Cox demonstrated that the irregularity of the stain can be attributed to the flattening of the shoe, and if corrected as if worn, these irregularities disappear. 16. Charles Mays' blood was identified in numerous blood spatter stains on defendant's clothing. 17. The defense's expert testified that the staining on defendant's outer shirt is consistent with defendant shooting and beating Charles Mays. See, that's never been debated, though, that they had a fight and all that. 18. The results for the samples taken from Charles Mays' sweatshirt, t-shirt, and underwear show the presence of DNA of 1 individual, Charles Mays. Perry Edwards, Virginia Edwards, and Eunice Zeigler were excluded as contributors. 19. The results for the samples from Charles Mays' pants show the presence of DNA of 2 individuals, Charles Mays and Perry Edwards. Virginia Edwards and Eunice Zeigler were excluded as contributors who had limited support for not being contributors. A. The bloodstains evidencing Perry Edwards' DNA on Charles Mays' pants were saturation stains, not spattered stains. 20. None of Perry Edwards' DNA was found on the upper half of Charles Mays' body. 21. No DNA from Virginia Edwards or Eunice Zeigler was detected on Charles Mays' clothes. 22. There is very limited support that Felton Thomas contributed DNA to Virginia Edwards' jacket. The Y chromosomal DNA test for this sample did not match Felton Thomas. 23. There is limited support that Charles Mays touched Eunice Zeigler's coat. YSTR testing cannot exclude Charles Mays as the contributor. The number of different alleles detected further supports, that is, makes it more likely that Charles Mays was the contributor. 24. The state's expert could not assign a sequence to the murders. Analysis and ruling. 1. Standard of review. Both claims raised by defendant depend on alleged newly discovered evidence. In Claim 1, defendant asserts that he's entitled to a new trial because newly discovered DNA evidence would likely result in an acquittal on retrial. In Claim 2, defendant asserts his conviction should be vacated because the newly discovered DNA evidence shows he's actually innocent. Newly discovered evidence claims seeking to vacate a conviction follow the standard announced in Jones v. State, Florida 1998. First, the alleged newly discovered evidence must have been unknown to the trial court, to the party, or to counsel at the time of trial, and it must appear that the defendant or his counsel could not have known of it by the use of diligence. Second, the newly discovered evidence must be of such a nature that it would probably produce an acquittal on retrial. Newly discovered evidence satisfies the second part of if it weakens the case against the defendant so as to give rise to a reasonable doubt as to his culpability. Swafford v. State, Florida 2013. When considering the second prong, the court must conduct a full and cumulative analysis of the evidence. Initially, the court must consider whether the newly discovered evidence is admissible at trial and whether any evidentiary bars apply. If admissible, the court must evaluate the weight of the evidence, including whether it speaks to the merits of the case and constitutes impeachment evidence or is cumulative to other evidence. The court does not review the newly discovered evidence in isolation. Instead, the court considers the admissible, newly discovered evidence against the backdrop of the evidence introduced at trial and previous testimony held to be procedurally barred or presented in another post-conviction proceeding. And it's referencing Lightbourne v. State, Florida 1999, Hildwin v. State, Florida 2014. In obtaining the total picture of the case, the court must consider all admissible evidence that could be introduced at a new trial. Swafford. Claims asserting actual innocence follow an even more exacting standard. Indeed, Florida does not recognize a freestanding claim of actual innocence. Tompkins v. State, Florida 2008. Daly v. State, Florida 2019. This is because Florida's standard for presenting newly discovered evidence claims is more liberal than the federal standard for actual innocence claims. To be sure, in federal courts, the newly discovered evidence for such claims must show that it is more likely than not that no reasonable juror would have found the defendant guilty beyond a reasonable doubt when compared against all other available evidence. 2. Defendant has failed to show the new DNA evidence would probably result in an acquittal on retrial, and claim 1 must be denied. For defendant to succeed on his first claim, he must show that the newly discovered evidence weakens the state's case against him as to give rise to a reasonable doubt as to his culpability. Or, in other words, he would probably be acquitted on retrial of the murders of Eunice Zeigler, Perry Edwards, Virginia Edwards, and Charles Mays. Well, I think it does. What do you guys think? A. Defendant's DNA evidence qualifies as newly discovered. The court begins with the first prong of the Jones test. The court finds the DNA evidence presented for purposes of this motion constitutes newly discovered evidence. Defendant has notably a long procedural history related to obtaining DNA testing of this nature. He was only able to conduct the current testing through the commendable stipulation of the state of Florida. In 2001, defendant conducted a prior round of DNA testing on a limited number of evidentiary items. Zeigler v. State, Florida 2007. The testing appears to be limited to polymerase chain reaction, PCR characterization. The current testing consisted of both the autosomal STR and YSTR testing. Autosomal STR testing appears to have been available since approximately 2001. It may even have been used in defendant's prior round of testing. The report is unclear. YSTR testing has been available since 2007. However, defendant's current testing further analyzed the results using StriMix statistical software tool. This software has been available since around 2015. Evidence from a comparable software program, Retrial, was first admissible in 2021. While STR and YSTR have been available for years, the development of statistical software such as StriMix for analyzing mixed DNA samples is relatively new. Furthermore, unlike the prior round of DNA testing, the current round provided much more exclusionary data, allowing analysts to exclude people as contributors to a sample. The court finds it to be based on sufficient advancements in DNA technology that were unavailable to the trial court, to defendant, or to his counsel at the time of trial. The court also finds that the defendant was diligent in his attempts to obtain such testings, but his motions thereon were denied by the court. Thus, the court finds this to be newly discovered evidence that satisfies the first prong of Jones. Well, that's like one win out of 10 zillion nods, right? B. Here we go. Nevertheless, it does not rise to the level of demonstrating a probability of acquittal on retrial. In reaching a determination on the second prong of the Jones test, this court has carefully read the trial transcript, the resentencing transcript, and the evidentiary hearing transcript. It has reviewed all evidence that would be admissible at retrial. The court begins this section with finding that colors all subsequent findings. At any retrial, defendant's credibility would be subject to substantial and weighty attack. Not only does the trial evidence refute defendant's testimony, but the newly discovered evidence further impeaches him. The evidence the state introduced at trial is still admissible. At trial, the state argued, or at least inferred, that the defendant held Perry Edwards under his arm and beat or otherwise struggled with him. The court agrees the new DNA evidence clearly refutes this, and it could not be argued at any retrial. But the new DNA evidence instead reflects a struggle between defendant and Charles Mays. Indeed, the defense's expert concedes that the new DNA evidence provides strong support for the hypothesis that defendant shot, beat, and ultimately killed Charles Mays. At trial, defendant unconditionally denied killing Charles Mays. As a possible explanation for some of the blunt force injuries Charles Mays received, defendant testified that he was wildly swinging a gun. But that would not produce the severe and deep skull fracture sustained by Charles Mays. Nor does it refute his own expert's testimony that the new DNA analysis indicates he is the one who beat and killed Charles Mays. Defendant argued at trial that Charles Mays' death was in self-defense because Charles Mays was one of the perpetrators of the murders of Eunice Perry in Virginia. Both parties have exhaustively argued that the killer of Perry, Virginia, and Eunice would almost certainly be covered in the back spatter attributable to the gunshot wounds they all suffered. Defendant's strongest contention for this motion is the DNA analysis does show, in fact, the lack of Perry, Virginia, and Eunice's DNA in the blood spatter on his clothes. The short of it being, if defendant's clothes lacked blood spatter from those victims, he could not have killed them. But Charles Mays' clothes also lacked such spatter. Perry Edwards' blood was only found saturated in Charlie Mays' pants. That fact is readily explainable. While the blood found on Mays' shoes and stains on his pants leg and cuff areas revealed a genetic profile consistent with Perry, these findings are consistent with Mays standing next to Perry or being in close proximity to his body after Perry was killed. These findings do not show, as defendant asserts, that Mays was the perpetrator rather than a victim of the crimes. Instead, if Mays was involved in a struggle with defendant while in close proximity with Perry's bloodied body, it would not be surprising that Perry's blood ended up on Mays' shoes and pants during the altercation. Well, that's because Charles Mays wasn't the only one. Zeigler v. State, Florida, 2007. Neither Virginia's nor Eunice's DNA was detected on Charles Mays. No blood spatter from Perry, Virginia, or Eunice is present on Charles Mays. Following the logic of defendant's own argument, Charles Mays did not kill Perry, Virginia, or Eunice. If Charles Mays did not kill Perry, Virginia, or Eunice, defendant's beating Charles Mays to death would not have been in self-defense. But he attacked Tommy. See, there's holes here, in my opinion. Defendant points to the fact that new DNA results provided limited support for the proposition that Charles Mays' DNA could be found on Eunice Zeigler's coat. Defendant argues that this touch DNA is found on places that one would expect to find it if Charles Mays had rearranged her clothing. But even if the court were to accept that as true, it does not prove or even tend to show that he killed her or the others. As previously noted, Charles Mays lacks any bloodstain evidence expected on the assailant of Perry, Virginia, and Eunice. Furthermore, while defendant minimizes it, Perry Edwards' DNA was found on defendant's shoe. Perry's blood was not found in the expected quantities, but it was nonetheless present in spatter stain on defendant's shoe. Even giving defendant the benefit of the doubt and accepting the total absence of Perry's blood on defendant, the Florida Supreme Court has already rejected this argument. Zeigler v. State, Florida 2013. The absence of Perry's and presence of Mays' blood on Zeigler's clothing did not establish that Zeigler was not the perpetrator. Yeah. It does not change that this court has already concluded the absence of Perry's DNA on Zeigler's clothing is not exculpatory. Defendant's argument as to Charles Mays and Perry Edwards is not the only place his testimony appears to lack credibility based on physical evidence. According to defendant, he was violently battered throughout the numerous different locations of the store. Indeed, he was thrown against the walls and furniture like chairs and a desk. Yet, as the treating hospital physician testified, other than the single gunshot wound, defendant suffered few other injuries. Defendant's other injuries were a single head contusion, 2 small abrasions, one of which was described as superficial, and a small bruise. He later complained of pain in the fingers, one would use to pull the trigger of a gun. These injuries fall far from supporting that defendant was subject to a violent and lengthy battery by at least 2 unknown individuals. He also testified he was shot, and shortly after he was shot, he began crawling around the store and over a body near the linoleum racks. The fact that defendant's own blood was found on his clothes indicates unsurprisingly that his gunshot wound was bleeding. The 2 bodies near the linoleum racks were those of Perry Edwards and Charles Mays. Perry Edwards' clothes showed no evidence of defendant's DNA. Indeed, defendant was excluded as a contributor in all but 1 sample. The same is true of Charles Mays' clothes. The court finds it improbable that defendant, after receiving a gunshot wound, was able to crawl over either Perry Edwards or Charles Mays without leaving a whisper of his DNA. Now the court discusses the evidence and testimony presented at the 1989 resentencing before Judge Formant. The court finds the testimony of Mr. Odom and defendant would be admissible at retrial. In that hearing, the state introduced evidence of defendant providing an inmate with the details of the murders to prepare yet another inmate to convincingly but falsely confess to the murders. Yeah, this was a bad idea on Tommy's part. While not a confession by a defendant, this evidence could certainly be viewed as incriminating. That's true. Furthermore, this plot involved attempting to pin the murders on the ski mask bandits. Indeed, at trial, he also attempted to point the finger at these ski mask bandits. Yet, in post-conviction proceedings, his argument has been that Charles Mays was the perpetrator. Zeigler v. State, Florida, 1995. Zeigler argued that DNA testing methods currently available may establish the bloodstains on Mays' clothing were from Eunice Zeigler or Edwards. Zeigler v. State, Florida, 2013, arguing that Perry's blood is on Mays' clothing, demonstrates Mays was the perpetrator. He points in one direction at the ski mask bandits, and the other direction is Charles Mays. The original jury rejected both arguments, and the new evidence does not provide any additional support for either. See, this is the only time that Tommy has an issue, in my opinion. But, To be sure, at that same hearing, defendant himself testified that the only reason he did not go through with the plan was that it would be too expensive. It suggests to this court that so long as the price is right, he has no qualms about presenting false testimony. Thus, the court reiterates defendant's credibility would undeniably be a major question in any retrial. A question a jury already resolved against him without the additional impeachment of DNA evidence and testimony that defendant is willing to pay others to present false testimony. Well, he was desperate, and yeah, it was a bad idea. The court now turns to the other incriminating evidence presented at trial. Incriminating evidence the new DNA results do not rebut. Witnesses at trial testified that defendant was seen around 7 p.m. driving Eunice Zeigler toward the store. Multiple others testified to defendants buying or owning guns used in the murders. A loaded pistol was found in the car. Defendant was using that night a loaded pistol owned by defendant and that was not present in the car when initially left with the defendant. That same car had a blue towel in the back seat when left with defendant. That blue towel was recovered inside a cabinet in the back of the store with Group A human blood detectable on it. That same cabinet also held a grocery bag containing cartridge cases consistent with those fired from one of the guns, the palm print of defendant, and human blood. Felton Thomas testified that defendant drove Thomas and Mays to an orange grove to fire guns that were carried in such a grocery bag. Yeah, the orange grove is... yeah. Indeed, Felton Thomas's testimony remains untouched by the DNA results. Defendant contends that Felton Thomas has since recanted his testimony. There you go. The court finds otherwise. No, he has. The only change to Felton Thomas's testimony is that now Felton Thomas alleges he personally did not fire a gun while at the orange grove. Of course, at trial he testified he fired the gun once, but whether while at the orange grove Felton Thomas fired the gun once or not at all, he still places defendant as driving him and Charles Mays to the orange grove. The orange grove from which a bullet was recovered that matched the class characteristics of the gun that killed both Perry and Virginia. A jury already found Felton Thomas more credible than the defendant, and the new DNA evidence is silent on this point. See, I don't think Felton Thomas is very credible either, but yeah. A jury also previously found Edward Williams credible. Again, there's a lot of credibility issues with some of these folks. In fact, multiple other witnesses corroborate different aspects of his testimony, including Mary Stewart, Frank Smith, John Grimes, Stoney Holland, Deputy Minor, and Deputy Park. The new DNA evidence changes nothing about any of those witnesses' testimony. A jury found all their testimony to be more credible than defendants once already. The court does not find that the new DNA evidence would make it more probable that a jury would alter that determination on retrial. Finally, the court wishes to address the problems defendant identifies with the first trial. Over the years, defendant has raised issues of judicial bias, juror misconduct, and state misconduct. Those issues may contribute to public perception of the judicial system, but those issues have long been decided against defendant and are procedurally barred. Zeigler v. State, Florida, 1984. Zeigler v. State, Florida, 1985. State v. Zeigler, Florida, 1986. Zeigler v. State, Florida, 1993. And Zeigler v. State, Florida, 1995. On this motion, the court must consider only the testimony and evidence admissible at a new trial. Defendant's allegations of judicial bias, juror misconduct, state misconduct, the length of the prior jury deliberations, and comments afterward are all inadmissible evidence on retrial. A great deal of the evidence in this case was circumstantial, but even at trial, much of it was not. This new DNA evidence may indicate the involvement of another actor, though this court is making no finding in this order that it does or does not. Even if it does show involvement, it would still not show that the actor was not part of defendant's plot to murder his wife, nor does the involvement of another actor alone exclude defendant's participation in the murders of Eunice, Virginia, Perry, and Charles. To quote from the state's closing argument at trial, Mr. Zeigler has hit us head on. Mr. Zeigler has made the issue. They are all lies, and I'm telling the truth. The evidence in this case, including the new DNA evidence, is strong evidence that defendant is at best telling partial truths. His own expert concedes that the new DNA evidence is strong support that the defendant killed Charles Mays, something the defendant expressly denied under oath. The same DNA evidence offers little to establish that Charles Mays was a perpetrator of the crime and not another victim. At trial, defense counsel stated, "We have other evidence such as FBI testimony, laboratory people, basically mountains of technical evidence, which all cumulatively raises a suspicion or the possibility or maybe even stretching it at the probability that the defendant might have done it." Of course, at trial, a probability of guilt is far from sufficient to convict defendant, but a jury found defendant guilty beyond a reasonable doubt. Actually, that's not true. There was a holdout juror. To vacate those convictions, this court must find that, on retrial, defendant would probably be acquitted. Having considered all the testimony and evidence of the trial, all admissible evidence could be reintroduced at a retrial, including the newly discovered evidence, and considering the total picture, this court cannot find that the defendant would probably be acquitted on retrial. The court finds the defendant has not met his burden and that claim 1 of his motion must be denied. 3. Because claim 1 fails, by necessity, so does claim 2. Florida does not recognize a freestanding claim of actual innocence. Even if it did, in failing to meet his burden under Claim 1, he cannot show entitlement to relief under Claim 2. As previously noted in federal courts, the newly discovered evidence for such claims must show that it is more likely than not no reasonable juror would have found the defendant guilty beyond a reasonable doubt when compared with all other available evidence. Defendant falls far short of this burden. Accordingly, it is ordered and adjudicated that 1. Defendant William Thomas Zeigler Jr.'s motion to set aside convictions based on newly discovered evidence filed on March 21st, 2025 is denied. Attached to this order and incorporated by reference are the applicable portions of record. Defendant has 30 days from the date of this order in which to file an appeal. The clerk of court shall promptly serve a copy of this order and its attachments upon all parties, defendant and the Attorney General, along with applicable certificate of service. The clerk is directed to serve a copy of this order upon the defendant, William Zeigler, and it lists his address at Union Correctional, and shall file an appropriate certificate of service in the file. Done and ordered in chambers at Orlando, Orange County, Florida, on this date, Letitia Marquise, Circuit Court Judge. Well, again, that was disappointing and long, and I decided to just continue with it, as you guys could tell. Yeah, it's just very disappointing to me. Now, I can understand some of where she's coming from what she has read, and I guess the law sort of precludes her from allowing certain things, which is really crap, but you know. The thing is, our justice system is supposed to punish the guilty and, you know, find the innocent really innocent, you know, and you know, so it's not a infallible system. You know, folks don't get sometimes the, you know, the right amount of time. Sometimes folks that should have been found guilty are found innocent, and vice versa. Okay, and then the sentences that are given are, to me, are very strange in a lot of cases. I mean, we've seen, you know, cases where there's like a point system, apparently. I've discussed that in these local cases. They have to have so many points to get this many years if they go to jail or prison. I mean, it's like the system that's supposed to work for the good of all people. I mean, I think we need to relook at it sometimes, you know? But I still believe that Tommy was screwed from the get-go. Yes, he lied. He lied when, you know, about a couple things. But you know what? We're all people. We're all human. I mean, people lie. I mean, he's admitted that he, you know, that he made up all that, you know, stuff to, you know, he tried to get somebody to take the fall for him, you know, the whole ski mask bandit situation. Tommy admitted that. And like I said before, it was stupid. It was really, really stupid. And I do believe, you know, he killed Charles Mays out of self-defense. Being he was so out of it, I think there was times he didn't remember all of it, you know, about exactly what happened between him and Mays. But I still don't understand how they can say he killed Eunice, Virginia, you know, and his mother-in-law and his father-in-law, Virginia and Perry, when he had no blood spatter on him. Okay? Nothing. And it's easy to get on his shoe if you walk in the blood. So again, to me, there's enough reasonable doubt with this DNA evidence to show that Tommy didn't do it. That there's more to the story. And no, it wasn't just Mays. There was at least 2 or 3 other folks involved. Okay, this was a quite larger situation that happened on December 24th, 1975, and seeing how this decision has come out, I just I'm going to continue to pray that Florida Supreme Court finds another way, but the history that we have seen and we just saw in Judge Marquis' denial shows that Tommy just hits the wall at every single turn. So it's really sad that I was hopeful for him, and I'm not giving up all hope. I'm not, but it's just not looking good for Tommy. And I think a lot of people are starting to see that as well. But please, please let me know your thoughts in the comments if you have followed this case, if you're familiar with it, and if you're not, I do have a playlist. I'll link to it in the information of this video. And there's lots of documents on the Orange County clerk's website. If you're interested, just look for William Zeigler. We call him Tommy, but his actual first legal name is William. So if you want to look him up there, you can totally do that. It is public record. But again, please let me know your thoughts in the comments. And with that said, I hope you have a great rest of the day. And most of all, stay safe.